This Honorable Court of Criminal Appeals of Tennessee is now in session.
Welcome, everyone, to this afternoon session of the Call of the May docket here in Jackson, Tennessee. Mr. Clerk, I'd like you to call the first case of the afternoon docket, and then we will let you be dismissed.
State of Tennessee versus Lavonte Lamar Douglas.
Thank you all for appearing today, and this will be the first case of the afternoon. I would like to introduce the distinguished panel that you have today. To my right and your left, from Blount County, Tennessee, Murrayville, Judge Kelly Thomas, and our newest judge from Montgomery, Robeson County area, Clarksville, Judge Jill Ayers. Judge Ayers was recently elevated from the trial bench to our court. We're glad to have her appointed by Governor Lee and confirmed by the House and Senate. And this will be the first time. She's been working longer, but this will be the first time she has sat on a panel of our court. And she's already heard two cases this morning, and we're going on our third. Each side is given 20 minutes. Wow, 2 minutes. 20 minutes per side, and you may reserve, the appellant may reserve whatever time they deem necessary upon introducing themselves to the court. We've had some technical difficulties this morning, and should they continue, we will just try to plod on. Be patient with us. We thank the staff of the clerk's office and the ALC for doing a fantastic job to allow us to be this way. We hope to be back in person in July, so look forward to that. With that, appellant, your time starts now.
Thank you, sir. Good morning, Judge Thomas, Judge Williams, and congratulations, Judge Ayers. And it's a pleasure to appear before all of you. My name is Valerie Corder, and I represent Lavonte Lamar Douglas, along with my associate counsel, Josie Holland. Neither Ms. Holland nor I tried Mr. Douglas's case. However, we have been very intrigued by some of the issues that came up during his trial, and believe that we'll be able to show this court that he is entitled to a reversal of his conviction. Mr. Douglas, the defendant, his first name is Lavonte. However, before Mr. Douglas was brought in for questioning, a gentleman named Kevin Douglas was the Douglas involved in this case. Excuse me, I forgot to reserve 5 minutes for rebuttal. May I do so now?
You've got it.
Thank you, sir. 4 gentlemen conspired to rob a Mexican restaurant in Bolivar, Tennessee. As a result of that evening's activities, Mike Ruiz, who was one of the cooks at the restaurant, was shot and killed. The assailants were wearing masks and were wearing black clothing and were not otherwise identifiable to the victims in the restaurant nor Mr. Ruiz. The suspicions after the Bolivar police interviewed the high school principal were that a Mr. Gray, a Mr. Blakemore, a Mr. Robinson, and Mr. Blakemore's brother, Jaquan Blakemore, were all vice lords, and 3 out of the 4 of them were late to high school the day after this event. One of them didn't show at all. The other 2 just came late. So these became the suspects that the sheriff's department was focused on. Very quickly, Javon Blakemore gave a confession, and Mr. Blakemore's confession was refuted by his second statement after he conferred with his brother and his cousin. His brother was Jaquan Blakemore. His cousin is Mr. Robinson. Mr. Blakemore originally said that he was armed only with a BB gun and he did not shoot Mr. Ruiz. However, another witness that the state called to testify at trial gave the testimony that he was driving the gentleman later that evening when Mr. Blakemore specifically said, "I shot Mike. I shot Mike." Mr. Blakemore denies that he said "I," concedes he might have said "we shot Mike." Mr. Blakemore's clothing was found in a vehicle. Mr. Blakemore was convinced to tell the truth and corrected his statement that he'd had a BB gun when he entered the restaurant with the intent to rob it that night, and admitted that he was trying to cover for his brother, Jaquan Blakemore, and his cousin, Mr. Robinson. These three gentlemen, along with a Mr. Gray, were Vice Lord members. The only person involved in this case that was not a Vice Lord member was my client, Mr. Lavonte Douglas. Originally brought in to be questioned was a gentleman named Tacyvin, Tacyvin Douglas. These gentlemen referred to one another by their last names, Blakemore, Douglas. Mr. Tavon Douglas, was not questioned by the police. He asked two questions of the detectives, wanting to know, did John Gray tell you my name? And once Mr. Blakemore confessed, they let Mr. Douglas go without ever questioning him. He was a 6 foot tall, left-handed black male who was also a member of Vice Lords. The only person who wasn't a gang member was my client. Lavonte Douglas was a 17-year-old high school student who was not known to Mr. Blakemore. Mr. Blakemore didn't know him from Adam, didn't hang out with him, didn't have classes with him, didn't socialize with him. And yet he was the person on whom the fault and the responsibility was dumped by Mr. Blakemore. Once the sheriff's office had Mr. Blakemore's statement, they stopped their investigation. They never took statements from the restaurant workers. They obtained no DNA, no fingerprints from the restaurant. They did not have my client's clothes that he was alleged to have changed into. They had no pictures, they had no DNA, they had no confession. All they had was an officer from the TBI, Mr. Pugh, who testified that according to his investigation, Lavonte Douglas was responsible for shooting the victim, Mike Ruiz. This came from Mr. Blakemore's statement. Mr. Blakemore's statement was never corroborated at trial and was never substantially corroborated by any evidence. There was no direct evidence. There was some circumstantial evidence because my client was 6 foot tall, an African-American man who was left-handed and wore black pants. A more general description, I couldn't tell you what it would be. Mr. Blakemore, having no ability to provide his own corroboration, the state put on the testimony of Agent Ayers and asked Mr. Ayers, was Mr. Blakemore's statement corroborated by Mr. Robinson? Now, Mr. Robinson had already been excluded as a witness in this trial. Mr. Robinson's statement had already been ruled inadmissible, and yet the district attorney, in what the defendant maintains was 3 acts of prosecutorial misconduct, thrice asked this witness what his corroboration for Mr. Blakemore's statement was, and 3 times this witness named the statement of Mr. Robinson. Mr. Robinson was a non-testifying witness. The defendant maintained then and maintains now that the admission of his statement through Agent Pugh violated the confrontation clause. He wasn't able to cross-examine this witness, and that this constitutional error mandates reversal of his conviction. Now, in responding to this argument, the state does not use the correct standard of review in their brief. They say it was a harmless error. In fact, an error of non-structural constitutional error is required to be reviewed by the standard that the state is required to prove beyond a reasonable doubt that those errors did not affect the jury. The state has waived this argument, has not even attempted to establish that the jury was unaffected by this testimony. And in fact, due to the paucity of actual direct evidence of my client's involvement, it is maintained that the state could not have persuaded this court and cannot persuade this court that this constitutional error didn't affect the jury. This error is significant because not just because of the lack of confrontation, but because it results in an insufficiency of overall evidence against my client. Yes, he's a black male who's close to 6 feet in height, and he's left-handed and wears black pants. That's all he concedes. He never made a confession. No one identified him. There were no fingerprints, no direct evidence whatsoever. Now, the final issue in my client's brief and in his appeal is one that has lately been commented on by our United States Supreme Court in the Mississippi case. It was Jones versus Mississippi. Justice Kavanaugh ruled that if there's no finding of permanent incorrigibility, that the court must have the discretion to sentence someone to less than life imprisonment or to violation of the Eighth Amendment. Now, I will concede that the Supreme Court was dealing with a life without parole situation when it made that ruling. However, I don't see the actual distinction between life without parole and life with the possibility of parole when it's a juvenile who has not been determined to be incorrigible and who we must presume has the ability to amend and correct his ways. Mr. Douglas is presumed as a juvenile to have the ability to change his behavior and change his moral values and correct his behavior, to be redeemed, if you will. The Eighth Amendment requires us to give him that consideration. Tennessee legislature, I believe it was last week, in the House passed a new bill. That bill states that when convicted of first-degree murder and sentenced to life in prison, that it will change the timing for one to meet the parole board from 52 years to 25 years. The defendant submits that this is the constitutional standard that we need to evaluate his case by. We admit that the Senate has not yet voted on this bill, but while it is being considered by the court, we can rely on Justice Kavanaugh's analysis for what is an appropriate and constitutionally sufficient standard in sentencing a juvenile for first-degree murder. And we maintain it would be that waiting 52 years to show that you can change or will be changed by your incarceration is far too long to redeem a juvenile. It appears that I have one minute left before my rebuttal time.
Yes, ma'am.
Justices, I've been an attorney for 40 years doing criminal work. And there are times when a case comes across your desk that does not allow the mind to rest easy on the result of the jury. And I would submit to the court that this is one of those cases. A 17-year-old with no direct evidence of him, and yet another man with his same last name and fitting the same profile, a left-handed 6-foot black man who wears black pants, who is a vice lord and who was originally suspected. It's possible that that jury got it wrong in that day-and-a-half long first-degree murder trial. We ask that the court reverse this conviction based on the 2 constitutional errors and submit Mr. Douglas back to the trial court for retrial. Thank you.
Thank you. You have your 5 minutes.
May it please the court, Brent Cherry for the state. The defendant argues today that the evidence is insufficient to support his conviction for felony murder because it consists solely of the uncorroborated testimony of an accomplice. Other than the testimony of the accomplice, Javon Blakemore, the following evidence establishes that a crime occurred and that the defendant committed it. And I'll walk through this evidence without talking about the accomplice's testimony, just to show the court exactly what the jury could consider before they got to the testimony of the accomplice. First of all, the employees of El Ranchito Restaurant in Boulevard, Tennessee, testified that around 9:00 p.m. on March 20th, 2018, 2 men in dark clothing came in, one carrying a pistol, the other carrying a long gun, to use their terminology. They came in the back of the restaurant demanding money, and the man with the long gun shot Michael Ruiz. So first of all, we have that testimony from the employees of the restaurant. Second, we have surveillance video from the restaurant where the crime was committed, and it shows 2 men in dark clothing entering the back of the restaurant. One of the men, shorter than the other, wears white shoes, carries a handgun. The taller man wears dark shoes, and his dark pants have a small patch or strip of white on the left thigh. The taller man carries an AK-47 style rifle and holds it to his left shoulder, his left hand on the trigger. Without provocation, he shoots Michael Ruiz in the chest and immediately flees. Mr. Ruiz staggers in apparent disbelief that he had been shot, and after a few moments, he falls to the floor. From the video, analysts determined that the shorter man in the video was 5 feet 9 inches tall, while the taller man who was carrying the rifle was 6 feet tall. Later, investigators determined that the accomplice, Mr. Blakemore, was 5'9", and that the defendant is 6 feet tall. Fourth, in the course of the investigation, police identified Javon Blakemore as the shorter man who went into the restaurant, and Mr. Blakemore confessed as to his involvement in the crime. Fifth, when investigators canvassed the area around the shooting, they found that a white Buick had been leaving the area right after the shooting. Sixth, Jeff Barnes, the principal at Boulevard Central High School in 2018, testified that 2 of his students drove white Buicks. One was John Gray and the other one was Brentarius Holmes. Brentarius Holmes then told investigators on the night of March 20th, 2018, he picked up Javon Blakemore and the defendant at the Rains East Apartments and took them to Whiteville. Next, during their investigation, police did not suspect Brentarius Holmes as being involved in the attempted robbery at El Ranchito because he had a pretty solid alibi. But they developed the owner of the other white Buick, John Gray, as the driver of the getaway vehicle. Mr. Gray also drove that white Buick, and Principal Barnes testified that his car was identical to the one driven by Brentarius Holmes. Next, when Principal Barnes viewed the video footage from a Shell gas station recorded a few hours after the murder, he identified the white Buick driven by Brentarius Holmes and 3 passengers, 2 of which were Javon Blakemore, the accomplice in this case, and the defendant, Lavonte Douglas. On cross-examination, counsel for the defendant challenged Mr. Barnes' identification of the defendant, and Mr. Barnes testified, "I was at school every day, and I know my kids. I see them in the hall, see them at breakfast, see them at lunch, see them in the parking lot, and I know them. And Lavonte had a walk, and when he walked across, I knew that was Lavonte." So that was his identification of the defendant, who was with Mr. Blakemore, with the white Buick at the Shell station a few hours after the murder. Next, in the video footage from the Shell station, the defendant is wearing dark trousers with a white spot on the left thigh. A still photograph of the taller man with the rifle leaving El Ranchito after the murder also shows him with a small white patch or strip on his left thigh. So there we have the shooter at the scene of the crime and the defendant at the Shell station, both wearing the same kind of clothing with that white patch, that little white strip on the left thigh. Next, when the defendant was questioned, he admitted that he was with Brentarius Holmes and Javon Blakemore that night when they went to Whiteville. GBI agent Matt Pugh retrieved the defendant's clothing after his arrest, and he testified that when the defendant signed the property receipt for his clothing, he signed with his left hand. So what do we know before we get to the accomplice statement in this case? We know the shooter is left-handed. We know that the defendant is also left-handed. We know the shooter is 6 feet tall. The defendant is also 6 feet tall. We know that the shooter wore dark pants with a white patch or strip on the left thigh. And at the Shell station a few hours after the robbery, the defendant was also wearing dark pants with a white patch or strip on the left thigh. And we also know that Javon Blakemore was a shorter man who went into the restaurant, and the defendant was with him that night. When we get to the accomplice testimony, first of all, when we look at all this evidence, this does suggest that the defendant was a part of this robbery. Now, it may not be enough to establish beyond a reasonable doubt that he was involved in this robbery, but it is enough for that slight corroboration that's required under the law. When the accomplice, Javon Blakemore, testified, he said that he and the defendant went in the back of the El Ranchito restaurant to attempt a robbery. Mr. Blakemore carried a pistol. Defendant carried a rifle. During the robbery, according to Mr. Blakemore, the defendant shot Michael Ruiz. Afterwards, they ran to a nearby location where they got into a white Buick driven by John Gray. Later that night, Brentarius Holmes picked them up in an identical white Buick and they went to Whiteville. On the way, they stopped for gas at a Shell station. So with that, based on the evidence presented, the state asserts that there was sufficient corroborating evidence to support the testimony of the accomplice in this case, and that the evidence is sufficient to support a finding that the defendant is guilty of this murder. Regarding the right to confrontation, the defendant complains that his right to confrontation was violated. At trial, TBI Special Agent Pugh testified about his involvement in the investigation of this case, and he testified that 4 suspects were developed. Javon Blakemore, the one with the pistol wearing white shoes, gave a full confession. Mr. Blakemore identified the other suspects: John Gray, who drove the getaway car and helped plan the robbery; Lavonte Douglas, the defendant in this appeal, who was the one with the rifle and the one who shot Michael Ruiz; and Taylor Robinson, a former employee of the El Ranchito restaurant, who helped plan the robbery and provided the weapons that were used. Special Agent Pugh testified that he interviewed Taylor Robinson several times and affirmed that the information that he received from Mr. Blakemore and the information he received from Mr. Robinson were extremely consistent. Later, during redirect, the state asked about the statements Mr. Blakemore made to different investigators, and the TBI agent, or rather, the state asked, he has consistently named Mr. Douglas as the shooter. How was that confirmed through the course of your investigation? Special Agent Pugh responded, well, through the course of the investigation, it was confirmed through another co-defendant's statement, which was Taylor Robinson. At that point, the defense objected and the court sustained the objection. So we have 2 instances here. We have a reference to information that was received from Mr. Blakemore and Mr. Robinson that was consistent. And then we have this other instance where the state asked, how was the information received from Mr. Douglas confirmed through the course of your investigation? Neither of those questions is improper, and neither of them could be termed as prosecutorial misconduct. In the defendant's reply brief, the defendant complains of 3 attempts by the state to make an inappropriate reference to the statement of Taylor Robinson. However, it appears that the defense may have just miscounted, because I can only find 2 references, and I would invite the court to go back and check the references to the record to confirm that, because I can only find those 2 references. The defense's claim of prosecutorial misconduct in the reply brief is raised here for the first time. And the defense argues that the state violated this right to confrontation, quote, the bell having been thrice rung in the presence of the jury could not be unrung, unquote. But again, there were 2 instances, not 1. As for the information that was received from Mr. Blakemore being consistent with the information received from Mr. Robinson, neither the question nor the answer made any reference to anything that Mr. Robinson said. So we hardly get to an issue of confrontation on that point. As for the state's question as to how Mr. Blakemore's identification of the defendant as the shooter was confirmed in the course of the investigation, the question itself was not improper, and the question could have been appropriately stated as, how was Mr. Blakemore's identification of the defendant as the shooter corroborated, which is the issue that we've been discussing here earlier. Again, the question was not improper and the defense did not object to it. But when Special Agent Pugh referred to the statement of Taylor Robinson, the defense did object and the trial court sustained the objection. And that was appropriate. We didn't need to get into the statement of Taylor Robinson if he wasn't going to testify and if there wasn't going to be an opportunity for confrontation. So that was proper, but it wasn't a result of any kind of prosecutorial misconduct. Afterwards, after the state asked the question again, Special Agent Pugh explained the corroboration without reference to Taylor Robinson's statement. He said, it was confirmed by, the physical evidence that was recovered as far as the videotape analysis that was done. We conducted a height chart. We had the FBI conduct a height chart on both the suspects that entered the restaurant. We also, the hand being left-handed, confirmed he was left-handed. All the information that was corroborated by Javon Blakemore during his statement and confession. Information, where they went following afterwards, who they talked to. So that was the answer that he gave after he was corrected and pointed away from anything that Mr. Robinson had said, and that was all proper. That's all part of what we've argued today is corroborating evidence. So when we look at this, the statement of Taylor Robinson, it was not introduced at trial. Special Agent Pugh's reference to the statement was fleeting. The trial court sustained the defendant's objection, and the defendant did not request a limiting instruction. So with that, this is a claim that simply is not without merit. It doesn't have any merit. And let's talk about the life sentence for a moment. The defendant argues that his life sentence is unconstitutional because it deprives him as a juvenile of any meaningful opportunity for release. The cases that the defendant has cited, Graham versus Florida and Miller versus Alabama, both are cases where there were mandatory sentences of life without parole. And that's simply a different kind of situation than what we're talking about, being a life sentence. Now, I've cited, or I'm sorry, I didn't write the state's brief in this case, but the state's brief does include references, citations to unreported cases where this has been considered, and the idea of a life sentence being effectively a life without parole sentence, it just doesn't hold up. And this has been something that's it's been raised in the federal courts, and while the decisions of the federal courts are not binding on this court, I think it's instructive for the court to consider something that the Sixth Circuit said in Atkins versus Crowell. This is a 2019 case from the Sixth Circuit, 945 F 3rd 476 at 478. In that case, the Sixth Circuit Court of Appeals, considered the federal habeas corpus claim of a Tennessee defendant who was convicted of first-degree murder and sentenced to life for the killing of his stepfather when the defendant was only 16 years old. As this court is well aware, for a petitioner to obtain relief in a federal habeas corpus action in a case such as this, he must show that the state court adjudication in his case, quote, resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, unquote. So in Atkins, the petitioner had to show that his life sentence was contrary to U.S. Supreme Court precedent. But the Sixth Circuit denied relief and explained why Miller, the Supreme Court's decision of Miller, did not apply. And again, the decisions of the Sixth Circuit are not binding on this court, but they're instructive. And here's what the Sixth Circuit said. Miller creates a legal rule about life without parole sentences, and whether one looks at Atkins' sentence formally or functionally, he did not receive a life without parole sentence. He will be eligible for release after at least 51 years imprisonment. Miller's holding simply does not cover a lengthy term of imprisonment that falls short of life without parole. Similarly, the facts of Atkins' case, the possibility of release after 51 years imprisonment, materially distinguish it from the facts of Miller with no possibility of release. The defendant argues that his life sentence is effectively a sentence of life without parole because he may not live long enough to get released, but all the Eighth Amendment requires is the hope of release. It does not require certainty of release. Thus, a mandatory sentence that an inmate is unlikely to survive is not prohibited by Miller. Our Supreme Court recently took up the question of whether a juvenile defendant's mandatory life sentence violates the Eighth Amendment in State versus Tyshawn Booker. That was argued in February, just a couple of months ago, and the court has not rendered a decision. But as the law stands right now, the defendant's mandatory life sentence does not violate the Eighth Amendment, and the trial court's judgment should be affirmed. Unless the court has any questions they'd like to discuss, the state would encourage the court to affirm the judgment of the lower court.
Ms. Corder?
Thank you, sir. I've been told I speak too fast sometimes, and if I do, please haul on the reins and slow me down. The state's the one that called Brentarius Holmes to testify to the. So if, as the district attorney's office says today, he was not involved in the actual crime, why did they call him? They called him because Blakemore confessed to him. Yes, my client admitted to being in the car with Mr. Holmes hours and hours after the robbery and the murder while at that 7-Eleven or whatever the gas station was. But there is absolutely no proof other than Blakemore's statement, which changed with the wind, that he was with them at the time of the murder. There's no proof that at the time of death that this Mr. Douglas, your defendant, Mr. Douglas, was present. Now, I disagree with opposing counsel when opposing counsel says that the corroboration was slight, but that's enough. As a matter of law in the state of Tennessee, slight corroboration cannot come from the constitutionally erroneous admission of statements of non-testifying co-defendants. Mr. Cherry says that it was only twice that Agent Pugh testified about non-testifying defendants identifying my client, Mr. Douglas. Our brief, page 17 and 18, cites to the record for 3 different incidents where Investigator Pugh referenced Mr. Robinson's corroboratory statement. And in fact, there were objections from defense lawyers. And the court asked that the district attorney rephrase the question. When rephrased, it was this. Was the information that you received from Mr. Blakemore the information you also received from Mr. Robinson? Was it consistent? Answer, it was extremely consistent. Now, we expect juries to be intelligent. How could they not know that Mr. Robinson had made the same allegations against Mr. Douglas that Mr. Blakemore did if they were entirely consistent? The state left that part out of their argument in their brief on page 32. I disagree also with opposing counsel that a mandatory life sentence, statutorily imposed and mandatory sentence, is constitutional. He states it does not violate the 8th Amendment, but if we read Justice Kavanaugh's opinion, what Justice Kavanaugh says is there doesn't need to be a finding of incorrigibility to be constitutional. There need only be the discretion to impose a sentence of less than life. There's no discretion in Tennessee. Statutorily, if one is convicted of first-degree murder, the sentence is life. With parole, without parole, to a 17-year-old, it makes no difference. It's a violation of the 8th Amendment according to Jones versus Mississippi. Opposing counsel also makes reference to the Howard Jefferson Atkins opinion in the Sixth Circuit, which I believe is on application for certiorari at this moment. I represented Mr. Atkins in the juvenile court, a 15-year-old also facing life in prison, and he will be 74 years old before he gets to face a parole board. That is constitutionally insufficient according to our United States Supreme Court. Your Honors, there were constitutional violations in this case which required the state to prove that the jury was unaffected by these mistakes. They made no effort to do so. There is a paucity of evidence against my client. In a circumstance where there were overwhelming evidence against my client, we wouldn't have these arguments. You would have a feeling of certitude, an assurance that the jury wasn't improperly affected by unconstitutional evidence. We don't have that assurance here because there was no direct evidence against Lavonte Douglas. I also would like to affirm that Mr. Cherry correctly advises this court that there is no Tennessee state reported opinion on this issue. The cases that they cited and the cases that we were forced to cite were all unreported opinion. I would state that on behalf of Mr. Douglas, it's time for Tennessee to take a stand. Is it constitutional to sentence a 17-year-old to prison when he'll be 52 years before he can have any hope of meeting the parole board. The defendant states that it is not constitutional and seeks a reversal of his conviction. Thank you very much.
Anything from the panel? Seeing nothing, thank you both for presenting your issues. We will take that under advisement and we will come back at 2 o'clock for the second case of the evening.
This honorable court is now in recess until 2 p.m.
Thank you.